see if Jeff was on here. No, he was tied up in another meeting, so he was going to jump out of that and jump into this. We're just giving everybody just a couple more minutes here in that, and then we'll get started. So thank you everybody for your patience. Stuff there. We'll go ahead and get started. So. Okay, it looks like we've got everybody here, and that we're anticipating. Others can join in and stuff as we go along, and that. First, I'd like to introduce myself. My name is Russ Means. I am the Minerals Program Director for the Division of Reclamation, Mining, and Safety. And in the conference room with me today, I have Jared Ebert, the Senior Environmental Protection Specialist, whose team has the Walstrum Quarry, and also Peter Hayes, who is the lead Environmental Protection Specialist for this application. Today's meeting and stuff is going to be from 2 to 3. We'll ask you all to keep your microphones muted and stuff during the division presentation. And following the presentation, we'll have an opportunity to hopefully have you ask some questions, and we'll answer them to the best of our ability. If you have a question, and that please use the raise your hand feature. And if you not familiar with Zoom and stuff and that, it's down in the bottom there, or if you just wave your hand frantically and stuff and that, we'll try to pick it up and stuff and that. So when if you do have a question and stuff, please identify yourself so that we know who we're talking to, and that it should pop up. But also if we need to take notes or something to get back to you and stuff, we want to make sure we have the right people. So what we're going to do today, this is an informal public meeting. It's not required by rule or statute, but it's just an outreach meeting and stuff to try to explain what it is that we do at DRMS, explain our application process, identify the issues and stuff that can become before the Mine Land Reclamation Board under our statutory jurisdiction, discuss the public notice process and the comment period, as well as describe party status. Froze up. There it goes. A real quick look at our organizational chart, just so that you understand who we are. We are the Division of Reclamation, Mining, and Safety. We're under the Department of Natural Resources. Jenny Brannon is our division director, and she's online and stuff here today. The division has 3 different programs and stuff. We have the Inactive Mines program, which does a lot of the mine safety closures on pre-law mines. And then we have the Office of Mine Land Reclamation, which has a coal program, and then it has the Minerals Regulatory Program, which is what construction materials and hard rock mines and stuff are regulated under. This big long legislative declaration in that this is the statute and stuff that gives the authority to the Mine Land Reclamation Board. The big takeout of this is it's the intent stuff to foster the encouragement and economically sound and stable extraction materials industry, as well as further aid in the protection of our natural resources, protect wildlife, aquatic resources, establish agriculture, recreational uses, and protect and promote the health, safety, and the general welfare of the state of Colorado. The Moneyland Reclamation Board is the expert agency established by the General Assembly to promulgate mining operations, permit and reclamation standards. DRMS staff serves as the staff to the board. DRMS administers the Colorado Land Reclamation Act for extraction of construction materials through CRS 3432.5. And what we do is we oversee the technical aspects of reclamation applications and permits to ensure that they meet the act and the rules. This is just a blurb and stuff for that, that gives us our authority both for construction materials under 3432.5 and also for hard rock under 3432. So our objectives are always to foster and encourage the responsible development of the state's metals and energy resources. One of our primary objectives is to ensure that reclaimed mined lands and stuff are back to a beneficial post-mine land use. It's important to note and stuff that we don't restore land. It's inherent that mining and stuff and that has an impact on the land. So what the reclamation is to ensure and stuff that it is brought back to some kind of use and stuff for the public or for the lands and stuff it's supposed to be intended to. We protect the environment by ensuring the regulatory compliance with our mine sites, and we coordinate with permitting, regulatory, and public review processes with federal, state, and local agencies where possible. And we implement interagency agreements for groundwater, stormwater, point source, and mine waste materials. It's really important to note that under our act and stuff, the operator has the responsibility of ensuring that the mining operation and the post-mine land use comply with local city, town, county, or land use regulations and master plans for the extractions of those materials. So we don't decide, the division does not decide where mining occurs, only that if it occurs, it's reclaimed back to a beneficial use. So, and that's what this next slide is. The counties in the state of Colorado have the authority to permit all aspects of land use for mining, and that includes this mining operation. We don't have the DRMS, and the Mine Land Reclamation Board does not have jurisdiction over certain matters such as noise, dust, traffic, hours of operation, visual impacts, and aesthetics. Those are all local land use issues and stuff like that that are delegated to the local jurisdictions. So one of the things is stuff that several of the processes and stuff that we're involved in are the permitting. We ensure financial warranty bonding and stuff for reclamation. We do inspections, and of course we do enforcement and stuff and that if there's violations of our act and our rules. And then we also ensure that reclamation is done according to the approved plans and stuff, and no site is released until it meets all of the requirements and stuff that are part of that approved plan. There's a lot of material and stuff that goes into an application for a 112C permit such as this. And it's important to note that while this site has been here for a while, an amendment is treated the same as a brand new application. So we go through and look at all of these different aspects and stuff when an application or an amendment is submitted to ensure that they meet the current regulations that are in play. It includes, of course, the mining plan, the reclamation plan. We look at water, wildlife, soils. We look at the cost of reclamation. We look at what permits and stuff and that are there or what might not be necessary and stuff now. We also ensure the legal right of entry, look at owners of record, municipalities within 2 miles, and we to make sure that man-made structures and geotechnical stability issues and stuff are all addressed. So now we're going to get into a little bit into our process. Prior to an application being submitted, an applicant has to submit a notice to the local Board of County Commissioners and the Planning Commission. They have to send a notice to the local Soil Conservation District, as well as placing a copy of the permit documents and stuff at the county clerk and the recorder's office. And they have to post a notice at the entrance of the proposed mine site. An application must be meet the requirements of the act and role in order to be considered filed. What happens with that is we get an application and we go through and we don't do a deep dive. We just ensure that all the exhibits and all of the required information and stuff for the basic application and stuff are there. Once that is done, the division has 10 working days in order to review that and get a notice out to the applicant if there's any deficiencies. If it's ready for file, we notify the applicant, at which time he must publish in the newspaper. For 112, it's 4 times, once a week for 4 consecutive weeks, and it has to be in a paper of general circulation in the locality of the proposed operation. By role and act, the initial due dates and stuff for that for a decision are 90 days, or it could be extended by 60 days if we consider it complex. And if objections are received, then the matter has to be scheduled before the MLRB. The division does not make a decision, only makes a recommendation to the board and stuff, and the board is the one that makes the final decision on that application. The final part of our review process and stuff is to look at what the financial warranty will be for the actual cost for fulfilling the requirements of the reclamation plan. In this case, the stuff we will be looking, we look at the current disturbances and the proposed disturbances and stuff in that and make adjustments accordingly. As noted, once the application has been filed, the division and stuff sends notices to the following agencies: to the State Historical Preservation Office, Colorado Division of Water Resources, CDPHE for Water Quality Control. We also sent another one to the CDPHE for the Air Pollution Control Division, as well as reaching out to the Colorado Division of Wildlife regarding wildlife impacts. Depending on where the site is, we may also have to reach out to the Bureau of Land Management or the Forest Service or the Department of Energy. If there's any impacts and stuff to potential for wetlands or streams and stuff, the U.S. Army Corps of Engineers is contacted regarding the 404 permit. There's also, we send notices and stuff to the County Planning Department, as well as the State Land Board if it's necessary, and the local Soil Conservation District. The operator has additional notices that have to go out once we consider it complete and once he starts his public notice process. It goes out to the notice of owners of record for the surface and mineral rights. They also have to send notice to any owners of record for all land surfaces within 200 feet of the affected lands, and also published in that newspaper and stuff as we discussed just a minute ago. The public participation part of this is comments and objections are allowed on all permit amendments, application amendments, and even surety releases. The division consideration is limited to our jurisdictional issues as dictated by the Act rules, and the timeframes for the division for consideration of comments and objections are defined by the Act and the rules. The comment period, I wanted to go into this a little bit more detail. As noted and stuff in that, the application must be meet all the requirements of the Act and rules to be considered filed. As I noted, within 10 days and stuff, they have to they have to start publication and stuff in a paper in the general locality of the proposed operation. And also, in the last couple of years, we have developed our website and stuff, and the application is posted on the division website for public review. you can go to our website and go to that section, and you can actually pull up the entire application. And that's actually the public file, so it'll have all the up-to-date documents and stuff in there. And there's also a form there to fill out and stuff, and that if you have if you wish to submit a comment either in support or in objection. So the comment period runs through the publication period of the paper, and then 20 days after the last date of publication. Objections and comments and stuff, we can receive them via email, hard snail mail, but our preferred method is through our website portal, and they have to be submitted by the close of business of that 20th day. If the comment period is missed, those comments must be considered untimely by the Act and the rules. However, that does not mean that we ignore them. We do take a look at those and look at the jurisdictional issues, no matter the timing, and ensure that all aspects of the application meet the requirements and that. So the division's initial decision is set by rule, as we discussed. And if the objections are received, then of course we schedule that for the Mine Land Reclamation Board, or in due course. So what we do in our reclamation plan review and stuff is we evaluate whether the plan will meet the stated post-mine land use. We ensure that the plan has enough detail to calculate an adequate reclamation bond. We ensure that the environmental compliance continues even if the mine is not in operation. And we ensure the site is geotechnically stable once reclamation is complete. Division staff has the authority to make a decision on a 112 application if there is no objections. However, as we noted, if there's an objection, then we have to take that to the board. All of the decisions and stuff that are made by the division can be appealed to the Mine Land Reclamation Board. And any enforcement actions that we take and that are actually brought before the Mine Land Reclamation Board, the division does not issue notices of violation, only a reason to believe that there is one. And with that, I'm going to turn it over to Peter, who's going to kind of go over some timelines and stuff of that, of where we're at with this application and stuff, and look over there.
This is Peter Hayes' division. So for this amendment application, the application was originally submitted to the division on April 20th. The application was considered filed for review on May 11th. The division deemed the application complex on May 12th. On June 22nd, the division conducted an on-site inspection for the amendment area and the existing quarry. On June 29th, the public comment period closed after the 4 required newspaper publications in the 20 period after that last publication. The division issued 6 advocacy letters on August 2nd, August 31st, September 10th, September 17th, September 21st, and October 13th. There was 3 general advocacy letters and 3 specific for geotechnical concerns. And then today, October 21st, is the informal informational public meeting. The division received 1 timely objection letter during the public comment period, and the division received 1 agency comment during the comment period from History Colorado. All objection and comment letters, including untimely, have been reviewed by the division and sent to the applicants. The review process has concluded. The process involves the exchange of review letters, division, and response letters from the applicant. Many of the jurisdictional concerns raised by objecting parties and non-parties are concerns of the division, which were addressed through the advocacy review period. Again, as Russ said, all permanent documents are available on our website. So that's my contact information, which I believe you all have already.
Okay, now we're going to switch over to Jeff Fugate. He's our Attorney General that represents the division, and he's going to explain a couple of legal issues and stuff there. Jeff, do you want me just to, you just tell me at some point you want me to move forward on the slides?
Yep, no, that works. I'll let you know when I need you to advance. Afternoon, everybody. My name is Jeff Fugate. I am with the Attorney General's office. I am representing DRMS in this matter. I've been representing DRMS since 2007. It's the same amount of time I've been at the Attorney General's office. So I appreciate you all making time for this. And I'm not sure if it's structured for questions after I discuss, but please, I'm available to answer whatever questions you all might have, just as the rest of staff is here. So again, my role is to provide legal advice to the division to help them implement the act and rules and to interpret any provisions that they may need assistance on. My role here today is to explain the party status versus non-party status as it relates to the hearings before the Mineland Reclamation Board. Party status it's an important legal concept. It does provide potential rights and obligations of a person participating in this process. So I'm going to walk through some of just the way that somebody can become a party in a matter. Again, anybody can participate as a party in a DRMS Mineland Reclamation Board hearing. I guess, Russ, maybe advance to the next slide here. So to acquire party status, they have to fall within the regulatory definition of a party. And then the second prong is they have to have filed a timely objection or comment letter to the application. Party is defined in our regulations in Rule 1.1, 34.1, and I'm just going to read this definition. A person who demonstrates that he, she, it is directly and adversely affected or aggrieved by the conduct of a proposed mining operation and whose interest is entitled to legal protection under the Act. So it's a fairly common party status definition. You'll find it in most environmental case law. Some refer to it as standing as opposed to party status, but it's really the same concept. In the Mineland Reclamation Act and in the implementing regulations, it is a two-pronged approach. So you have to show that you are directly and adversely affected by the proposal and that the way in which you are impacted or affected is something that's within the jurisdiction of the division and board. So that's that second prong, whose interest is entitled to legal protection under the Act. The other component of acquiring party status is that you have to have filed a timely letter of objection. Again, this is governed by Rule 1.7.1. Typically, if you file a late objection letter, you are not afforded party status. Next slide, please. So to cover more specifically non-party status, this really covers a kind of a range of folks. It's anyone who does not meet the regulatory definition of a party. They choose not to be a party. They didn't file a timely comment letter, or they fail to fulfill some of the party requirements. Those requirements are parties are required to attend the pre-hearing conference, which I'll discuss briefly here in a little bit. If they fail to attend the pre-hearing conference or assign a proxy to appear on their behalf, then they forfeit party status. The other way that they can lose party status is if they don't appear for the hearing itself. When you do lose party status, essentially you're losing your ability to participate as a party in the hearing itself, but you're also losing the ability to file a reconsideration motion with the board. And you also don't have the legal right to file a judicial review or appeal of that final board order. Those are rights that are associated with somebody who is a party to the matter. The second bullet point on this slide is probably important for this group. Subject to board approval, if non-parties want to address the board on a matter of concern, in every agenda before the board, there is a public comment section of that agenda where members of the public can come and discuss matters with the board. Now, this is not part of the hearing itself. It's not part of the Walstrum pit hearing, which is going in November, but there is time at the end of the hearing day where you can raise your concerns with the board. You can also submit written comments to the board if you want to. You can submit something and send those directly to the board as your public comment if you're not able to appear for the hearing itself. In the past, usually the board limits public comment to 2 to 3 minutes, depending on how many people wish to participate in that public comment time period. Next slide. As I indicated, there is a pre-hearing conference set in this matter. And I can't remember the date. Maybe Peter, it's next
November 4th.
November 4th. Rule 2.7 governs the pre-hearing conference process. The purpose of this pre-hearing conference really is to kind of create an order for the board to follow as it's considering this application in November. It describes the division's review process. It discusses and resolves contested issues if that's a possibility between commenters and the applicant. It tries to narrow the list of issues to be considered by the board. And then it also kind of allocates time for parties to present to the board, and it creates the order of presentations. It really is just kind of the script that the board typically follows during the course of the hearing on this matter. Next slide. Just like that's it. So I mean, it's again the party status, non-party status. I know is of particular importance to this particular group. I think that's one of the main components of why we decided this informal informational meeting was important, was to kind of be available to field any questions you all may have. So with that, Russ, I'll turn it back over to you.
Okay, great. With that, we'll open it up for questions, and that Mr. Agar and stuff like that. Forgive me if I pronounce your name wrong and stuff like that, but Dan, you can go ahead and please ask your question of us.
Thank you, Russ. My question's relating to the party status. I believe we had demonstrated party status from earlier objections we had to Fry's Quarry, and we should have been included in a notification at the beginning of this process for the amendment to the Walstrum Quarry. Because we were not notified and we knew nothing about this application until the period was actually closed. It seems that we should not have to forfeit our party status just because we should have been notified, very simply. Thank you.
Russ, if I can ask just a couple questions. Dan, thanks for the question and comment. I guess, would you fill me in on when you said you've commented on prior applications? Are you referencing
about our homeowners group, the DMRA, that represents the Douglas Mountain parties involved in this matter, the homeowners?
And when you said that they've commented before, what, I guess, give me a reference, or maybe give division staff a reference on what was that comment related to? And
well, I believe we had a number of objections previously. We can document them because they are on record in the archives. So just on that fact alone, it seems that we clearly are a party of interest here, and we were not notified, and therefore we should not be prevented from commenting as a party to this matter. Did you hear all that?
I did, yeah. I was just pausing to see if anybody else had anything to say. I didn't want to step on toes.
Thank you.
You know, not knowing kind of the details of your prior objections and when those were received. Typically, when the division receives an application process, or an application, whether it's a new application or an amendment, it does commence a new comment period. You know, I think you likely are an interested party, but that is legally distinct or different from somebody with party status to a particular application. Our act and rules are fairly rigid and strict as to how somebody can become a party to a pending application, which is different from somebody who may have an interest in a pending application. And so, you know, because a comment was submitted at a prior application doesn't necessarily afford you party status in a newly submitted application, if that makes sense.
It does not make sense. Thank you. We clearly should have been notified. I mean, we are the most affected party in this whole matter.
Right. And Russ and Peter outlined some of the notification requirements under Act and rules. They were followed in this process. The direct notice is limited to those within 200 feet of the affected land boundary. There's publication in a local newspaper as required by the Act and rules. So that's the process that was followed here.
Yeah, we drove by the entrance to the quarry. I assume that's where a sign should have been posted, and we certainly saw no sign on numerous. We drive by there regularly.
We observed a sign during the pre-operational inspection on June 28th. So it was posted at the entrance there.
I'm just saying, was it posted in a public manner where it would have been noticed by the public?
It was on at the very front of the entrance.
Well, the public doesn't go into the entrance.
You wouldn't have to go into it. You can see it from the street.
I realize the stuff, that entrance and stuff, and that is wild and stuff and that, but it was posted and stuff that was accordance to the Act and rule. I understand, it may trying to drive through that area and stuff and that it may have been not as easily visible as as in some other places and stuff, but it didn't comply with the Act and rules. So. I see there was somebody that had their hand up.
Mary.
I think Mary had, I can't pronounce, I'm sorry, I didn't see your last name now, but Mary, if you would like to, please unmute and ask your question for us.
Hey, Russ, there's also let's see, it looks like Meredith Reyes, who also she just raised her hand via the camera.
Okay, yeah, I can't see everybody here. So, for some reason. So anyway, Mary, please ask your question.
First of all, I'd like to just clarify what Daniel was saying regarding the previous objection. I'm looking at a letter from the Douglas Mountain Residents Association dated December 15th, 2004, objecting to a proposed change there. That's what Daniel was referring to. But anyway, if we could, I'd also like to talk about the notification process. And I'm sorry if I'm asking you to repeat something you already covered in your presentation. But is it part of the notification process that you have to notify Board of Commissioners of affected counties?
The Clear Creek, right? Clear Creek County and stuff, where the affected lands and the permit area and stuff, where they were notified, yes.
What about Gilpin County and the affected land of the fines dump?
The fines and stuff are outside of the affected lands for the permit. And that's under Gilpin County under it's like a special use permit or whatever. And so the activities and stuff there are regulated by the county under their conditional use permit, not under the DRMS permit.
So you have no jurisdiction over the SURs?
That's correct. Back in 2007, the Mine Land Reclamation Board and stuff issued a declaratory order, and part of that process in 2007 was because the county had a conditional use permit over that area and that site and stuff. They relinquished the jurisdiction of that to the county and stuff for the county and stuff to maintain.
Okay. I would also like to talk about your rules and notification rules, and particularly the notification, the publication of in newspapers, which to me seems like a very outdated method of notifying people. Again, there were no objections filed against this permit expansion because there was no awareness in the community. And publishing an article in an obscure newspaper that I think is published once a week in Clear Creek County, but not in Jefferson County or Gilpin, it's kind of disingenuous. It's really not informing the public at all. There's better methods in this day and age of electronic media and stuff. There's better ways to notify people. I understand you got to follow your rules, but your rules are outdated and maybe somebody needs to address that. Thank you.
Can, just to follow up and stuff and that, and I don't argue and stuff that I mean, the newspaper process and stuff is rather antiquated. And that's why we do stuff on our website and everything else. But what would you suggest would be a proper way and stuff to do a notification?
Well, for example, we met with Mr. Fry yesterday, and he said for the next, correct me if I'm wrong, for the next phase of this process, with maybe Colorado Division of Public Health and Environment, I think. But anyway, they've got a long list of people that they intend to notify, interested parties. So something like that, there should be, I mean, obviously DMRA, our Residents Association, should be notified, but it wouldn't be that difficult to find to create a list of local homeowner, property owners. That would be easy to compile. Electronic notification, I think, is a whole lot better than outdated weekly newspaper, community newspapers.
Yes, I do. I would like to.
Okay. Well, that's something that's stuff for us to consider and stuff. And I mean, as we move things, what we talk about the notice of the entrance of the mine and stuff there. A few years back, we actually changed our rules and stuff and that because some of the operators were putting an 8.5 by 11 sheet of paper and stuff at the entrance. So we went in and we looked at it. We actually made changed our rules and stuff to be more in line and stuff with like the county land use permit sizes and stuff for that. So we defined that in that. But to do that, what's required and stuff and that is we have to go in and do a rulemaking and stuff and do formal processes, and we do that periodically. So it's something that's stuff that we'll take a look at. But unfortunately, that's not the system and stuff that we have right now.
I understand.
So I'm not, so I understand it. I took a note of that, and so certainly it's something that we can we'll take a hard look at that and have some conversations and stuff on that to see what we can do and stuff in that. But also and stuff, no matter where we draw a line, somebody's going to be on the other side of that line, right? So if somebody's going to be anybody that's within 1,000 feet or 2,000 feet, oil and gas have offsets and things and stuff and that. So no matter where we draw a line, there's going to be somebody on the other side of that. So we also have to take a look at that. And this site is really kind of interesting and stuff, and the fact that there's 3 counties that are all touching and stuff and that, which complicated things, which is not in any way, shape, or form and stuff that normal and stuff for 99.9% of our applications and stuff and that. So I recognize that, and we'll have further discussions on that. It doesn't help us out at this point though. So, but it's duly noted.
If I can follow up on just one other point. Oh, sorry, go ahead. I didn't mean to interrupt you.
I was just going to make one closing comment to reinforce that it was a lack of awareness in the community. Obviously, you've gotten tons of objections that are now untimely. That proves my point that there is interest in the community. There just was no awareness.
And I was going to say, one of the points on the publication in a local newspaper in the general location of the proposal, that's not only set by regulation, it's set by statute as well. So it's not something that's easily changed by a rulemaking process. As Russ indicated, there are ways that we can add to that, but because it's statutory language, it's not something that the board has the authority to change. That's for the General Assembly to change if there needs to be, or kind of an updating of that particular publication. Notice and outreach is something that I think the division staff is always working on, as to how to make sure that there's a broader net cast when something is published. As Russ said, right now by statute and rule, it's a 200 foot from the permit boundary, or I'm sorry, the affected land boundary. That's the starting point. And that's where the division works off of.
That's good. Thank you.
Are there any other questions at this time? I don't see any hands up.
Russ, can you, yep, it's Miss Rayhace.
Yes, thank you. Yes, Rehus.
Thank you.
Just to clarify again, it was our president of the DMRA, Bill Derlin, who signed but did not author the letter to the board objecting to the previous expansion of the Fry Walstrum quarry. I think you said the year was 2004, but can't remember exactly because I don't have the copy in front of me. But that was our initial entry into this whole situation and why we think we should have been notified this time around.
Thank you. So I don't see any other questions and stuff there. This group will be notified. We will have our pre-hearing conference, and it will be on Zoom and stuff. And non-parties will be able to listen in by YouTube, and that they just won't be able to participate in that process and stuff there. So but you'll get an invite to that, and so that you can keep in line with that process and stuff. And you'll also be notified of the mine land reclamation date and stuff for the hearing.
Russ, it looks like we have another hand up.
Oh, okay. Do I know?
Hi, this is Dylan DeMail. Thanks for taking the time to chat today. I just had a quick question. If you could please define what locality refers to with respect to the notification. Is there a strict definition of that?
Locality is not generally defined in our act and rules. I think we take kind of a reasonableness standard. We look for the paper in the locality of kind of the vicinity of the mine. In this case, it happened to be the Clear Creek Current. That's the county where this is in. That's where the affected land lies. That's the most appropriate paper in which they should publish. I know Jared or Peter, if you have anything to add to that.
No, that pretty much covers it.
Yeah. And
Okay, thank you. Just a quick follow-up. So this is kind of an unusual situation because the affected land is in one county, but the affected residents are primarily in another. So it seems especially easy to meet the letter of the law, but not the spirit of the law in that regard.
I understand that. I think part of the party status issue and stuff, and that is is through the acts and the rules and stuff, and that defines what that party is and stuff, and within our jurisdictions and stuff. And when we go through that and take a look at it, you're not within 200 feet. We went through the checkbox and stuff and that of what we have and stuff for party status and that, and it didn't meet the requirements and stuff for you to be there. As Jeff explained, it's being a party to a past process and stuff doesn't guarantee you a party status and stuff for a new action. And that's where I think there's a little bit of confusion there. And I'm not discounting and stuff in that view. Understand that, but and I noted and stuff on this one and stuff. This is an unusual one and stuff where the county lines and everything else are. But we didn't look at the county lines and stuff when we were looking at the notices. We looked at, were you within 200 feet? The answer and stuff there is no. Were you a municipality within 2 miles? The answer there is no. Did you, were you a legal right of entry landowner or anything like that? The answers and stuff there are no. So I'm not going to, we'll talk, as Jeff noted, and that this is covered by the act and the rules. We can change our rules, but the act and stuff is a legislative requirement and stuff, and that which is a far different lift and stuff for us and and for the Department of Natural Resources and everything else and stuff. But we'll take a look at that and we'll have some conversations and stuff on those kind of things. And being an interested party doesn't necessarily, as noted, as grant you party status and that, or a right to be notified and stuff in that, although I could see some merit and stuff in that in future discussions, but it doesn't help us right now. Jeff, do you have anything else to add to that? So. I don't see.
So we've got Marty Fast.
Marty
His
Fast.
hand up.
Yes, my name is Dennis Fast, and I live on Douglas Mountain. And I have two questions. You said you have your meeting on November 4th. What is your, two questions, what is your timeline? And the second question, if and when you approve your permit, what is the process after that?
So the pre-hearing conference and stuff has to be held by under Rule 2.7. It has to be held a minimum of 10 days prior to the Mine Land Reclamation Board hearing, and then the division has to issue our letter of recommendation, whether that's for approval or denial and stuff, 3 days prior to that pre-hearing conference. So the pre-hearing conference is November 4th. So the our letter of rationale will be issued and stuff on November 1st. And then out of that process and stuff, the board meeting and stuff, and that's going to be, I don't have it in front of me and stuff, I think November 18th.
November 17th.
17th and stuff in that. So that's the timeline and stuff we have. Then if then it's up to the board to make that decision and stuff, and then from there, there can't be an appeal by a party of that decision, and if that's exhausted and stuff and that, then it goes to district court.
And if I'm interpreting, if we're a non-participant or a non-affected party, the way you folks are looking at us, so what my question is, if you do approve the permit, what is the process after that? Does the permit go to another government agency for approval before the quarry is before the expansion is approved, or what is the process?
Okay, I like to explain who we are and stuff, and that maybe I should have done that at the beginning. We are just one part of an umbrella, a regulatory umbrella. And under our act and our rules, all other local, state, federal permits and stuff have to be issued before this is before any activities in this amended area can happen. So the county, Clear Creek County and stuff probably has a process and stuff that has to be gone through, and I don't have the applicant here or anything else, so I don't know any of the particulars about that on that. But the county has to approve it. You know, we send notices to the to CDPHE and stuff. All those permits and stuff and that all have to be in place. If they're in place, they may have to be amended in order to go into these new areas. So all those other process permits and stuff have to be in place and stuff prior to any disturbances and stuff within this area. We can approve it. The board can approve it. But if any of those other processes and stuff and that are denied, then nothing moves forward. And that's happened before. So we've gone through an application process. We've approved it, or the board's approved it, and the county or some other jurisdiction decides and stuff that's not a big deal and stuff. So that stops the process right there.
Okay, thank you.
All right. Okay, Barry, I think you have another question.
So I am unclear about when a non-party may give a 2-minute or 3-minute statement to the board.
Okay, on the regular agenda for the board and stuff, there's always a public comment period. and stuff. It's on every agenda and stuff there. So it's set and that, so if you wish to make comments and stuff, the thing and stuff to do would be to send an email and stuff to the board administrator, Kemi, and that she's actually on here and stuff. And but we can send you when we send you the notice and stuff on the hearing, there will be an email and stuff there to go ahead and make a note and stuff that you wish to have public comment. And you can also put them in writing too, and submit them and stuff so that they're there for the board and stuff and that to review and that. So
am I understanding then that we will be notified about the meeting since we are involved in this process? Or we are supposed to be prepared before the 17th?
We'll because you're an interested party, we're going to send you a notice and stuff on when the board hearing is going to be. Yeah.
Okay, that's great. I appreciate it. Thank you.
You bet. Okay.
I want to clarify, and this is for anybody else who may want to participate in the public comment portion of the hearing. You do have to reach out to Kemi Mohar with your information so that she can provide you access to the hearing. So that's your obligation to reach out to her and let her know that you want to take advantage of the public comment option of the board hearing.
And her address is she on the website?
Yeah, it'll be part of the notice and stuff that gets sent out to everybody.
Okay. All right. Thank you.
I'm just making sure we double. Yeah, I know it's on there, but I will double check and stuff. We'll triple check to make sure that Kami's email address and stuff is there. So, all right. Any other questions? I don't see any. All right. With that, what we'll do and stuff and that is we will close the meeting and stuff and that.
Hold up, Russ. We've got one more question. The name is Karen Pavick, but I don't know if you can go ahead and unmute yourself, sir.
I can't see the whole list for some reason. So, all right. So, okay.
Sir, you're still muted. Mr. Pavick, you're still muted. Mr. Pavick, your microphone is still muted. Should be down in the, up there you go.
There we go.
There you go. Sorry about that.
You hear me?
Yep, we got you.
I'm Gary Pavick. I'm a local resident up here. And like a lot of the residents, I'm just getting into this, surprised that we've got this going on. I've been out of town quite a bit. But my question, first of all, was there was a lot of good information on your slides that you came, and I wasn't able to take enough good notes. I wonder, is that information going to be available on your website anywhere, or meeting notes of this particular meeting?
We can certainly, yeah. Well, you know what? We'll make a copy of that available and stuff. We can put it in the permit file, and if you and we can put it on the website. And that's
okay.
There'll be a link and stuff there because we are recording it right now. And that,
yes,
and that just had that's just our normal protocol. But we'd be more than happy and stuff to put that PowerPoint stuff online and stuff so you guys can see that. That'd
right. And I'd have to say, I would like to second what Tim mentioned, and that is, you know, I don't know, you know what the speed limit is out in front of the quarry. Posted a sign over by the quarry entrance and people going by at 45 miles an hour. I mean, you're not, you know, you can't expect anybody to get anything out of that. First point. Second point, Gilpin Current. I defy you to find anybody up here in this neighborhood, Douglas Mountain area, the 50 or so homes that are going to be impacted with this mining venture. I defy you to find anybody that's got that paper, has ever had that paper in their household. Okay, it's just not something that anybody is ever going to get. So I guess I'd just like to say that, and now we'll have to follow along with it the best we can. But Yeah, I guess I gotta say, I'm pretty disappointed that that we didn't see any previous notification, especially to the homeowners association. That is just, that's pretty bad for us.
Duly noted.
Yeah, okay.
Okay, but
That's
we'll
all I
make
have.
sure that PowerPoint and stuff is available to you.
I'll take a look at it. Thanks.
All right, you bet. And forgive me, because I can't see the way everything is set up here, so I can't see the other hands or anything like that. So I'm not ignoring anybody, I just can't see the hands.
Well, this is my first Zoom meeting because I retired from the state previously, so I haven't had to do a lot of meetings on Zoom at all. So I'm getting the hang of it.
Great.
Okay.
Okay. All right. Well, thank you, sir. Cammie, do you see anybody else?
Nope, I do not.
Okay. With that, we will conclude today's meeting and stuff. If you have any additional questions or whatever, and that you can send them to Peter and he will forward them on either to myself or to Jeff Hugate and we will go from there. So we appreciate your time and that to talk to us and like I said, your concerns and stuff, a lot of them, some of them are non-jurisdictional. The ones and stuff that are jurisdictional, we have taken a look at those. And some of your issues with notifications and stuff and that are on some notes for some future discussions and stuff. So thank you again.
And Russ, real quick, we put Cammie's email up in the chat box.
Okay, Cammie's email is in the chat box. Okay, thank you. So, all right, Cammie, if that's it, then we're concluded. Thank you.
Thanks, everybody. I'll go ahead and end the meeting. You guys have a good day.
Somebody's email up in the chat box. Well, that's all happening pretty much right away. November 4.